I'd like to start by situating myself. I'm a settler of mainly Scottish heritage. I was born and grew up in Regina, Saskatchewan, and my father's grandparents homesteaded in the sort of the extreme southeastern part of Saskatchewan, south of the Moose Mountains. They aren't really mountains, they're really hills. There aren't mountains in Saskatchewan, as most of you know. So that was back in the 1880s, before the province got created, and it was just a few years after the Prairie Treaties in the 1870s. And my grandparents' farm, or my great-grandparents' farm, is actually in Treaty 2 area, but for some reason it seemed to shift into Treaty 4 area, and I think the line between those two treaties geographically wasn't very clear on the ground. In any case, when I grew up, and we didn't live on the farm, okay? We lived in Regina, and relatives lived on the farm. But in the family, there was no idea at all that this land had been acquired by the Crown from First Nations people, and that our right to live there came from a treaty, right? We thought, well, just got a government grant, right? There was a Homestead Act, and that's the way it worked, and this was government land, and so no understanding of the treaty and the fact that our permission to live there came from this treaty with Indigenous people. Well, I obtained a BA in history from the University of Saskatchewan in the late 1960s. But even then, I learned practically nothing about Indigenous peoples or about the treaties. I didn't learn that it was the treaties that permitted people, the settlers like my family, to come and farm on the prairies. So it was only after I started working as a research assistant at the Native Law Centre, it's now the Indigenous Law Centre in Saskatoon, that I started to become aware of these issues and started to develop an understanding of Aboriginal treaty rights. So that became the focus of my research and my academic life. So the panel that I'm on is about Aboriginal treaty rights, but in Canadian law, they've been defined pretty narrowly as rights recognized and defined by the Canadian courts. It's the Supreme Court of Canada that has defined Aboriginal title to land. It's not defined by Indigenous legal systems from the point of view of Canadian law. Also, the Supreme Court has not addressed the issue of the international dimensions of Indigenous rights. In particular, the matter of Indigenous sovereignty is avoided by the courts, and most recently in two cases from last year. One involved a reference on the constitutionality of the First Nations, Inuit, and Métis Children, Youth, and Families Act, and the other one is known as Gitxsan and Vuntut Gitxsan First Nation, involving the powers of a First Nation government in the Yukon. But in each of those cases, the Supreme Court avoided the issue of Indigenous sovereignty, which in Canadian law terms is usually referred to as the inherent right of self-government. Down in the United States, it is referred to as Indian or tribal sovereignty. Okay, so my focus is going to be not on Aboriginal rights and title as defined, for example, under Section 35 of the Constitution, but rather on sovereignty and treaties. That's what I would like to talk about. So sovereignty is really a European concept that developed out of the medieval period as nation states began to emerge, and in particular France, so the King of France and then the King of England, as they asserted their independence from the Holy Roman Emperor and from the Pope in Rome. So you end up in Europe with the development of this concept, which then gets recognized and accepted by the law of nations, which is the old name for international law. But it's really, this law is European international law, right? It gets spread throughout the world, but we had to realize that it was the European nations that created this. And they created it without input from other places in the world, India, China, Africa, without input from the indigenous peoples, and yet it's being imposed on them. Okay, by the 16th century, so before North America was colonized by the Europeans, sovereignty had come to mean, in this European sense, absolute jurisdiction or absolute political control by a ruler over a given territory. So in Europe, France, England, Spain, Portugal, and other states, and smaller entities, which are really more like city-states and principalities and so on. So this was the concept, this idea of absolute sovereignty was the concept that was acknowledged in Europe by the Treaty or the Peace of Westphalia in 1648 that ended the 30 Years' War. And by that peace, it was sort of recognized as this is the universal idea of the law of nations, and this is what governs the relationships between nation states. And it was this concept of sovereignty developed by the European powers that they had in mind when they colonized the Americas. And they applied this concept of territorial sovereignty among themselves. So they each claimed vast areas of land based on papal bulls, based on discovery, based on royal charters, symbolic acts of possession, and so on, as though they could acquire original sovereignty over the territories of the indigenous nations in North America. However, that was in theory, and that was their relations that they were conducting among themselves. But they had to deal with the reality on the ground. And the reality was that early on, the indigenous peoples were more powerful, much more numerous, had more military power than the European nations. So the European nations had to enter into agreements with them. And so treaties were entered into, and these treaties were not treaties necessary to acquire land. They were treaties of peace and friendship to establish good relations, but also to acquire permission for the Europeans to actually settle in North America. The treaties involved indigenous laws and protocols as well as European laws and protocols. So indigenous peoples in North America, and this is part of what we're talking about in the colloquium, indigenous peoples had their own international laws that governed their relations with one another, and they drew on those when they encountered these newcomers and started to enter into treaties with them. So a prominent example of such a treaty is the two-row wampum belt treaty that the English entered into with the Haudenosaunee in 1664 at Albany, which is now in New York State. The Haudenosaunee, also known at that time, it was the Five Nations Confederacy called the Iroquois by the French. So by that treaty, the English and the Haudenosaunee agreed to enter into peaceful relationships with one another, and that they would be bound together by a covenant chain. And that this chain had to be polished from time to time to renew the relationship. In other words, it was a recognition that the treaties were not just one-off things, but they were creating relationships by which people and nations could live together within the same territories. However, the British, under this Two-Row Wampum Treaty, and the Haudenosaunee were to remain independent and were never to interfere in one another's affairs. In other words, these were nation-to-nation arrangements. They were international. And they were happening at the same time that in Europe, the Europeans were acting as though they already had sovereignty, but they didn't, right? And they acknowledged that in the treaties they entered into with the First Nations in North America. This Two-Row Wampum Treaty was renewed in 1764. So this is the year after the Royal Proclamation, the year after Britain acquired French Canada from France. So in 1764, there was a large gathering at Niagara in what's now Ontario, and this treaty was entered into, the Niagara Treaty, that reaffirmed the Two-Row Wampum Treaty and extended it to other nations in the Great Lakes area. So there were about 2,000 First Nations people representing many nations, so it wasn't just the Haudenosaunee who gathered together at Niagara. So, as I said, that was the treaty relationship. It was a nation to nation, and the idea was that the British wouldn't interfere with the First Nations in their own governance of themselves. Now, these treaties were actually inconsistent with the Westphalian concept of absolute sovereignty, whereby there had to be just one sovereign over a distinct territory who exercised complete authority there. So the sovereignty in these treaties is really a relative sort of sovereignty rather than an absolute sovereignty. So two or more nations could, in fact, be sovereign within the same territory, right, at the same time. So this, I think, was the kind of sovereignty that was envisaged by the First Nations and by the European powers when they entered into these early treaties. The problem, however, was that the Europeans and then the Americans after the United States became independent and Canadians after Canada became a country in 1867, they did not respect these treaty relations. So at the end of the American Revolutionary War in 1783, Britain and the United States signed a bilateral treaty, an international treaty under international law, whereby Britain recognized the independence of the United States as a new nation state. And the treaty drew a line on the map from the Bay of Fundy on the Atlantic side up through 4 of the Great Lakes and then on to the Lake of the Woods in what is now northwestern Ontario. Now, no Indigenous people were involved in the negotiation of this treaty. They didn't sign it. They did not agree to it, even though this line cut through the territories of many Indigenous nations, including the Haudenosaunee. And the Haudenosaunee were very upset over this. They had this Two-Row Wampum relationship with Britain, and Britain had just ignored it, and in fact ceded a large part of their territory to the United States. So some of the Haudenosaunee actually moved to Canada as a result of this. But it's an example of how the European powers, after entering into these treaties, did not, in fact, respect them or abide by them. Okay. The problem, too, for the Indigenous peoples is that they were now outnumbered by the Europeans, right? And they did not have the same military power to resist colonization. And so the Americans and the British in British North America, that's north of that international boundary that got drawn, they ceased to treat the Indigenous peoples as allies. And in British North America, they started to treat them as subjects, and they just assumed south of the border that the United States had sovereignty, north of the border that Great Britain had sovereignty over territories. And they weren't necessarily, these nation states, United States and Britain, weren't necessarily in control of these vast territories, but they still claimed them. And they did so in violation of the Two-Row Wampum Treaty and the Treaty of Niagara and other treaties they'd entered into with the Indigenous peoples. So despite decisions by the United States Supreme Court, this was Chief Justice Marshall, 3 decisions in the 1820s and 1830s, Johnson and McIntosh, and then the 2 Cherokee cases, second of which is Worcester and Georgia in 1832. In spite of those decisions that acknowledged the continuing sovereignty of the Indigenous nations within the United States, so acknowledging that there was shared sovereignty there, by the 1880s, the Supreme Court had invented a doctrine known as the plenary power of Congress. So Congress, the Supreme Court said, could take away and reduce Indigenous sovereignty at will at any time, also take their lands, violate their treaty rights and so on, because Congress had plenary power over the Indian nations. So that was in the United States. There's this continuing acknowledgement of Indigenous sovereignty, but it's subject to the overriding sovereignty of the United States expressed through Congress. In British North America, what became Canada, the treaties entered into in Upper Canada in the first half of the 19th century were regarded by the Crown as land surrenders. So the colonial governments treated the Indigenous peoples as though they lacked sovereignty. So Great Britain just treated them as though they did not have sovereignty, Britain had sovereignty, so the treaties were no longer treaties of peace and friendship. They were treaties that from the government, from the British government side, they were treaties that involved acquisition of lands for settlers. That's not the way the Indigenous people saw these treaties, right? For them, they were still negotiating as nations with another nation, and they were agreeing to share some of their lands and to share sovereignty, but not to give it up. Same thing with the numbered treaties in Western and Northern Canada, starting in the early 1870s. So Canada thought that it already had sovereignty over these areas, and the Indigenous people did not have sovereignty. And Canada thought it got sovereignty from Britain through the Rupert's Land and Northwestern Territory transfer of these territories to Canada in 1870. Now, of course, the First Nations who entered into these treaties did not see it that way. Okay, they thought that they were still independent nations, and what they were agreeing to, as I said a few minutes ago, what they were agreeing to was to share their land with settlers who they knew were going to come in, and to share political authority, to share sovereignty with the Canadian government. There's an excellent book which talks about this, Treaty Elders of Saskatchewan. Our dream is that our peoples will one day be clearly recognized as nations. And it was compiled by the late Harold Cardinal and Walter Hildebrand. And what they did is they went around Saskatchewan and they interviewed elders. And so the book has many long quotations from these interviews with elders, and they were asking them what they thought the treaties were about and what the First Nations had agreed to. And I think the elders are unanimous that there was no intention to give up sovereignty, that they thought that they would continue to have political authority over their own peoples and their own territories, but they were going to share the land, they were going to share political authority with the Canadian government. So what we see is that in the 19th century, starting in the 19th century, the United States and Canada shifted their position from the earlier relationships of shared sovereignty that was reflected in the Two-Row Wampum and Niagara Treaty and other treaties that they had entered into. And they shifted their position to the Westphalian idea of absolute nation-state sovereignty. Now, I think, and please correct me if I'm wrong on this, I think Indigenous peoples today are pushing back against the application of the Westphalian concept of sovereignty in North America. And rightly so, because that concept was not the way in which North America was colonized, and it violates the original understanding of what the treaty relationship was all about. It violates the understanding of the Indigenous parties to Treaty 2, for example, when they agreed to allow my family to settle in what is now southern Saskatchewan. Now, I do see some glimmers of hope, okay? First of all, in a very recent decision of the United States Supreme Court, the case is known as Halland and Brackeen in 2023, the court did begin to question the plenary power of Congress. So Justice Barrett, for the majority, said that plenary does not mean absolute, but she doesn't give a lot of detail on that. Justice Gorsuch, writing only for himself though, said that the plenary power is not consistent with tribal sovereignty. And he referred back to Chief Justice Marshall's decision in Worcester in Georgia in 1832. So that's one hopeful sign. In Canada, as I mentioned earlier, our Supreme Court has been avoiding this issue of Indigenous sovereignty. It has acknowledged that the Indigenous nations were sovereign before the Europeans started colonizing what is now Canada. And it first acknowledged that, as far as I know, in the Haida decision in 2004. But the Supreme Court has not explained what happened to that sovereignty, right? Or how the British Crown and then Canada was able to acquire sovereignty over the landmass of Canada without conquest. The Supreme Court said the Indigenous peoples here there wasn't any conquest. If they had sovereignty before, then the only other way the Crown could have got it is through cession. And Indigenous peoples say the treaties weren't about cession of sovereignty. And even Canada didn't think the treaties were about cession of sovereignty because it thought it already had it, right? So Canada does not really regard the treaties as the source of its sovereignty. And we know, how discredited the idea of the doctrine of discovery is. So this is a big unanswered question. And, especially in areas like most of BC where there are no treaties at all, how could the British Crown have acquired sovereignty here without some agreement with the Indigenous peoples? Okay, so, I think Indigenous sovereignty must still exist. And as I said, the Supreme Court, though, has been avoiding the issue, but it's not really up to the Supreme Court, is it? And it's really up to Indigenous people, I think, to assert their sovereignty. Now, another hopeful sign is the UN Declaration on the Rights of Indigenous Peoples and the promise by Canada and by British Columbia to implement the UN Declaration. Now, I don't have time to go into it in any detail, but there are many of its provisions, I think, support continuing Indigenous sovereignty. And in particular, Article 3, which reads, quote, Indigenous peoples have the right to self-determination. By virtue of that right, they freely determine their political status and freely pursue their economic, social, and cultural development. And then Article 4 goes on to be a bit more specific. It says, Indigenous peoples, in exercising their right to self-determination, have the right to autonomy or self-government in matters relating to their internal and local affairs, as well as ways and means for financing their autonomous functions. Now, the signs of hope I see are all really, well, the UN Declaration was drafted with a lot of input by Indigenous peoples, right? But what the US Supreme Court is doing, what the Canadian Supreme Court is not actually doing, but these are external sources, right? So the sovereignty of Indigenous peoples does not come from these sources. You know, it must come from their own political systems, their own laws that were in place when the Europeans arrived and have continued to apply within their communities ever since that time. And so that is the source, right? What we see from the UN Declaration or from the US Supreme Court is acknowledgement of that, but it's always rather limited, right? It's more expansive in the UN Declaration than we see in court decisions. But it's for Indigenous peoples themselves to assert their own sovereignty and to tell Canada and the United States what it's all about and what the relationship is all about. So I'm going to end that there. This has been very broad, but I really hope that it will stimulate, discussion and questions and so on.
Nigan nanaskamon kesemanitu atam skatanawel kakio ogimauk seno kihu and sigasin winasipi ochinia sagao Mushkegowuck ekote noahkompen nohkompan ekiutsi ni musumpan ote Gitxsan nanaskamage okeota kamikwiakak. Hello everyone, my name is Ogimauk Seno Kihu, which means the old man eagle. And when I was given this name, I was explained that, you'll become a spokesperson for our people. And one day, if you uphold that responsibility, you'll sit amongst the grandfathers who held that responsibility before you. And the name comes from the Plains Cree people. I have another name, Minasin, which means to be nice or to be good. And that was given to me by my Nohkumpan, my late grandmother. And she came from the swampy Cree people. And I have a third name, Wadite, which is a name of a nachnach, or a supernatural being amongst the Gitxsan. And in our flood narrative with the Gitxsan, we converted our longhouses into these houseboats. And as they were floating on the flood waters, and they were connected with a great big cedar rope. And the people started to run out of food and resources, and they were starving. And then a supernatural being came, and he had a very unusual appearance. He had, light brown hair, hazel eyes. He looked like no one they had seen before. And he had a power with him. It was a Galdum Galimpta magic lunchbox that never ran out of food. And so he fed the people and saved them. And when my mom was pregnant with me, my late grandfather had a vision in which a young boy came running up to him in this dream. And the boy had the physical characteristics of Wadite. So he thought that was a sign that I was, this being coming back to us. I come from a couple different nations. On my Nohkumpan, my late grandmother's side, I'm Mushkegowuck or swampy Cree, And our family originates at the Winniskseepee, or the Groundhog River, which flows into the Hudson's Bay in northern Ontario. And during the fur trade, we moved into York Factory and participated in the trade there. And then following the fur trade, we ended up being relocated by the government to Churchill, Manitoba, which is where my late grandmother grew up. I'm also connected to the Cree community through my wife, who's her father is from Onion Lake Cree Nation in Saskatchewan. And so I find a lot of my learning recently has been actually by traveling out to Saskatchewan and spending time with my father-in-law and his siblings. And they've been a really great blessing in my life. They're all fluent first language Cree speakers who have just been really immersed in the culture out there. So I've been really blessed to get to learn from them and to reconnect with that side of my heritage. And then on the other side of my family, we're Gitxsan, and I'll show you this this photo here. This is of a place which we call Damlahamid, and in the origin story of my house, there was a big battle in which all of this village was everyone was killed. And the only survivors was a grandmother and her granddaughter who were out in seclusion doing the coming of age ceremony, which we call ginit, or to rise up in our language, of this young woman who was rising up into her status as a woman. And when they came back from the forest in the time of isolation, everyone in their village was dead. And so the grandmother calls out to the four directions to see who will marry this granddaughter. And all the different animals come in their human forms and offer themselves, but none of them is good enough. And then finally a supernatural being comes and demonstrates his power. And the grandmother says, okay, you can marry my granddaughter. And he takes her with him up into his home, up in what we call Laha, which is like the heavens or the sky, or even some elders translate it as outer space. And there's a whole nother, realm up there with, land and the villages and stuff. And so they go to the village where the supernatural being comes from, and she gets married to him, and they have 3 children. And these children are given gifts and instructions from the chief in that longhouse up in Laha, and they're placed on earth, and they become ancestors of my house and ultimately of Gitxsan. And they found a village which they call Damlahamid. And the root word of Damlahamid is Laha, or the heavens. And so Damlahamid means paradise, the place on earth that mirrors the reality of that realm up in the heavens. And so they're given different gifts and instructions. They're told how to build longhouses. They're instructed to make the first totem pole. They're instructed to make the first coppers of our nation. And they do all these things, and they create Gitxsan civilization. And they're also given instructions which we call ayoknie, or the laws of our grandfather. And that's our concept for natural law. We, of course, have many different types of law within Gitxsan. We have different kinds of positive laws as well. But this particular aspect of our legal order comes from that origin story as well, and the instructions that were given in those origins. So that's a bit of an introduction to who I am and some of the where I come from. My house on the Gitxsan side is called Hachwagot, which comes from the root word is gwot, which means to become lost or obscured, and that refers to another part of that origin story in which there's a subsequent battle after they come to Earth, and the power of this particular ancestor is he could call upon the fog to obscure the location of his army during this fight, and he uses it to get maneuver around the enemy and get an advantage. But I also have relatives with other houses through our lineage or kinship network. So I also have family in House of Lelt, House of Gillawa, House of Gitxsan as well through those kinship networks. I'm an associate at White Raven Law. I'm a lawyer. We do it's a boutique law firm that represents Indigenous governments. We have done a lot of work with the Haida Nation, both preparing for a Haida title case, as well as negotiating agreements on behalf of the Haida Nation as well. And I taught at the law school at UBC for a few years now, but I've taken a step aside from teaching to just focus on my family and on my law career as well. I have a beautiful wife, Rebecca Baker-Grenier, and she's Kwagil, Tsawadenu, Squamish, and Cree, and we have 2 beautiful children together as well. So today I'm going to I'll go back to this. I'm going to talk about three things. One, I'm going to make an argument for reframing the jurisprudence on Aboriginal title and shifting our understanding of it as a sui generis property right towards a right that is an interest in land that's public law in nature and is grounded in the sovereignty of Indigenous nations. I'm going to look at two examples of, what is this, looking at title in this way, what does it mean for submerged lands and water and oceans? And I'll also think about what does this mean for, title to fee simple or private lands. And then I'll conclude with looking at relationship to land within the Cree legal order and thinking about how would this new or different conception of Aboriginal title make more space for the operation of Indigenous understandings of relationship with land that don't accord with this European concept of what property looks like. So, as you guys, I'm sure already know, Silcoteen is the leading case on Aboriginal title in Canada right now. It was a groundbreaking case in that it's the first time that a Canadian Supreme Court of Canada granted a declaration of Aboriginal title. And the court reaffirmed and clarified the test that it had previously established in Delgamuukw for proof of Aboriginal title, underscoring that there's three criteria for proving occupation. You have to show that the occupation was sufficient, that it was continuous, where you're relying on present occupation to infer historical occupation, and also that there was exclusivity. And Silcoteen describes Aboriginal title as a sui generis title to land that is held collectively by the Indigenous nations, and which includes an exclusive right to use, manage, and benefit from the land, subject to the restriction that the uses must be consistent with the group nature of the interest and the enjoyment of land by future generations. Silcoteen also states that at the time of the assertion of European sovereignty, the Crown acquired radical or underlying title to the land, all the land in the province, and that Aboriginal title is thus a burden upon Crown title. Now, the problem with describing Aboriginal title as a burden on this underlying Crown title is that this reinforces a colonial power dynamic in which an imbalance between the Crown and Indigenous nations, in which our title is seen as something lesser than what the Crown actually has. And so characterizing Aboriginal title as a property right proved through use and possession of lands thus diminishes Indigenous nations into groups of collective landowners. So it ignores the fact that we have our own governments, it ignores the fact that we have our own laws, and just sees us as collectives of property holders. And you can even see this in the nature of the tests out on Silcoteen as well. It's very, very similar to the test for adverse possession or squatters' rights. That's kind of a metaphor for how the courts see us as these lawless people squatting on our own land. And even though the court doesn't explicitly say that, it's implied in the way in which the court characterizes the nature of Aboriginal title as a property law interest. So Indigenous academics and lawyers have advocated that the courts reform their articulation of Aboriginal title to emphasize that it is a public law right, a right that's held by a government, which includes ownership, decision-making authority, and jurisdiction over territory, which derives from the laws and the sovereignty of Indigenous nations. So a really great article that explores this argument is by Doug Sanderson, Amo Banashi, as well as Ampital Singh, and the article is called "Why is Aboriginal Title Property If It Looks Like Sovereignty?" So Sanderson and Singh argue that the court's description of Aboriginal title does not comport with a sound theoretical understanding of a property right. Aboriginal title is much more akin to a right of a sovereign to make laws about the use of a territory. And they make three main arguments to support this claim. First, they say that property does not contain internal constraints on its use. It's only externally constrained by whatever limitations are imposed by governments in law. So like if you have fee simple land, that's like the basic concept of fee simple is you can do whatever you want with it unless, the legislature comes in and restricts it through, whatever laws. Whereas if you look at the way Aboriginal title is described, is it actually does have an inherent limit that First Nations can't use the land in a way that would deprive future generations of being able to have, access to the benefit of those lands. And so that's an example of an internal constraint over Aboriginal title, which makes it not really look like a property right. Whereas in comparison, if you look at Aboriginal title as a right, a public law right that derives from sovereignty, public law interests in land are always inherently constrained in that in democracy, our governments are representatives of the people, and they're meant to act in a way, not like a dictatorship, or they're meant to act in a way that actually is for the common benefit of all the people, all their constituents. So that internal restriction about using it in a way that's for the benefit of current and future generations, that aligns much better with this sovereignty-based conception of Aboriginal title. A second argument is that fee simple does not contain any constraints on alienation. Its defining feature is that fee simple lands can be bought and sold by anybody. Yet Aboriginal title has a restriction on alienation. It can only be sold to the Crown. So at first glance, this appears to be a paternalistic restriction based on the assumption that Indigenous peoples are incapable of protecting their own lands. So this goes all the way back to the Royal Proclamation, in which King George III says, in light of all the frauds and abuses that are happening to Indigenous people, in which they're selling their lands directly to unscrupulous settlers, that the Crown is going to come in and assume this benevolent and paternalistic role of being the middleman in these transactions. The First Nations can only sell their land to the Crown, and then the Crown will sell it to everyone else. So the origins of this concept are definitely colonial and paternalistic. But Sanderson and Singh argue for reshaping the basis for this rule, and saying that actually, if we see Aboriginal title as a public law right derived from sovereignty, then the reason why First Nations can't sell Aboriginal title as an interest to regular people is that regular people aren't sovereign. Regular people can't acquire jurisdiction and lawmaking power or whatever by purchasing that from a First Nation. Only other governments, meaning the Crown and presumably other First Nations as well, could acquire Aboriginal title interests through this way. So the third argument which Sanderson and Singh make is that Aboriginal title derives from sovereignty because it requires proof of Indigenous laws to establish it. And here's a quote explaining that a bit more. They say that another important feature of Aboriginal title is the manner in which it's established. Claimants must prove the existence of Aboriginal title by reference to land laws or a system of tenure of the group making the claim. When it comes to common law title to land, possession, even adverse possession, is all that's required to prove one's right to the land. But Aboriginal title requires more because Aboriginal title cannot be exactly the same as fee simple lands. Aboriginal title is sui generis. Proof of Aboriginal title requires not just proof that the land was held, but that the land was held pursuant to a distinct set of Indigenous laws created by that Aboriginal society. Aboriginal title has a genealogy in Indigenous lawmaking, and indeed takes its content from Indigenous law. And once again, this suggests that Aboriginal title is not a property right. So I just have some random pictures distributed throughout this presentation on my family's dance group, just to break up all the text. So let's look at these two kind of case studies or examples for what does this shift in understanding actually mean in practice. And one of them is that reframing our conception of Aboriginal title to a public law interest in land based on Indigenous sovereignty has profound implications on, for example, it allows the concurrent existence of fee simple and Aboriginal title to the same piece of land. So if we look at Aboriginal title as a property right, then this doesn't make sense, because you can't have two people with exclusive use and possession to the same piece of land. It's like, well, whose land is it? It's mine or yours? And it creates this all or nothing approach. And it results in an irreconcilable conflict with finding fee simple to the same lands, for how can two parties each exercise exclusive possession of the same land? So the plaintiffs in Delgamuukw and Silcotin avoided this issue by exempting private lands from the claim area, and this perceived conflict was the basis of a recent case, Osgoode Nation versus New Brunswick, in which the province of New Brunswick brought a motion arguing, among other things, that it's not possible to have Aboriginal title and fee simple coexist on the same parcel of land. But the court in Osgoode rejected the province's argument. So the court noted that the implication of a declaration of Aboriginal title on fee simple lands would ideally be resolved through reconciliation negotiations, and the court foresaw that this could kind of take two different routes. One is that the First Nation could receive damages to compensate for the alienation of fee simple lands which were on Aboriginal title lands. And the court also said that it is possible that if needed, it could also be addressed through either compensation by damages or even by the Crown using its expropriation powers to repatriate fee simple lands back to the First Nation. And I think a good example of an analogy for this is what happens in fraud, where someone fraudulently sells a piece of fee simple land to someone else, and the buyer is referred to in law as a bona fide purchaser for value. So they acted in good faith, they bought the land, and they thought that they were doing everything lawfully. And by analogy, you could see the Crown as the person committing fraud. They're selling a title, parcels of land to which they don't actually have title. They're Aboriginal title lands, and they're selling it to this innocent third party. And usually what the courts do in these instances of fraud is that they'll make the person who committed fraud liable to the actual original owner of the land, and they'll pay the market value of the land back to that original owner. But also in certain circumstances, if the original owner can argue that there's something unique or distinct about the piece of land that was stolen and sold that can't just be purchased in another comparable parcel of land, then they can argue for, getting the land repatriated to them, and then the Crown, and then the fraudster then pays market value to the bona fide purchaser. So I think that's an interesting and pretty an analogous example in law to what's happened here on this broader scale within our country, with the Crown selling off lands to which they haven't actually established title to. So this is still a preliminary motion that this judgment comes from. The issue hasn't actually gone to trial yet, so it'll be really interesting to see how the court in this case handles the issue of title to private lands. There's another very similar motion that happened in the Haida title case. So in this case, BC and Canada made similar applications to the court, asking to add all third-party landowners as defendants to the title case. This would have had a crazy effect because there's thousands of landowners. So you imagine a case with like several thousand defendants, that would just be totally unwieldy to litigate. So the court denied this application, finding that this would make the title case impossibly complex. And in the application, the court also said, British Columbia argued that there can be no coexistence of a right to exclusive possession conferred by both Aboriginal title and fee simple to the same lands. The plaintiff submitted that both rights can coexist given the sui generis nature of Aboriginal title, which confers rights in addition to the exclusive possession, such as the ability to regulate land under Indigenous law or the ability to impose taxes. These are all, public law expressions of authority. So while there is no authority that Aboriginal title ousts fee simple or vice versa, the plaintiffs say that any Crown grant of fee simple does not extinguish Aboriginal title. So in this case, then even if the beneficial interest has been given away to a third party, the First Nations can still have underlying title analogous to Crown title. And in that case, what's unresolved at law is if you have both underlying Indigenous title and underlying Crown title, how do you reconcile those two jurisdictions? And the courts haven't even asked that question yet, so they haven't answered it. But one day, hopefully. So the court agreed with the Haida Nation's arguments that they were plausible, and they left the matter to be decided at trial, and they denied the Crown's motion. So the court's decisions in both Wolastoqey and Haida implicitly reject the notion that Aboriginal title is merely a property right and align instead with an understanding that Aboriginal title is a sui generis a public law interest in land derived from the sovereignty and the jurisdiction of Indigenous nations under their own legal orders. In this situation, the fee simple holder would retain the beneficial interest in the land, while the Aboriginal title holder would continue to exert public law powers such as taxation, lawmaking, along with retaining underlying title to such lands. Professor Burrows published an article in the wake of the Tsilhqot'in decision where he considered how would Aboriginal title apply to private lands. And he said that neither private property nor Aboriginal title is absolute under Canadian law. And he advocated for a system in which the two interests could coexist. And Professor Burrows in this article talked about how, for a long time, the Indigenous interest in such lands has been, blatantly ignored by the courts and by the Crown, and how, reconciliation involves, considering the interests in both sides and trying to find some kind of a compromise. And then Burrows also notes in the article that Indigenous laws contain ideas around property that aren't necessarily as rigid and exclusive as the Crown Canadian law way of looking at it, and there's potentially solutions within Indigenous legal orders themselves on how to coexist on lands. So another thing I wanted to point out is that there's recently this Gaigalchid Gitxsan Rising Tide Haida Tidal Lands Agreement, as well as a recent Chihujin Chowcalga Big Tide Haida Tidal Lands Agreement with BC and Canada, respectively, in which provide a practical example of reconciliation of Aboriginal title with fee simple interests. So in these agreements, for example, this first one, the province recognized that the Haida Nation has Aboriginal title to its entire terrestrial portion of its territory, which is unprecedented. What you see in other modern treaties is First Nations getting maybe 5 or 8% of their lands back is in the form of fee simple. In the Haida agreement, they got their entire Haida title to their entire territory recognized, which includes fee simple lands, and in return, the Haida consented to the continuation of fee simple lands that are held by third parties, that the third parties could continue to hold those lands, and that the province would retain jurisdiction to regulate those lands under provincial law. And this worked in the Haida because there's only about 2% of Haida Gwaii is actually private lands. This type of arrangement might not be as practical in areas like Victoria or Vancouver, more urban areas in which there's a lot more private lands on the nation's territories. But yeah, the Rising Tide Agreement is really interesting because it jumps ahead in the conversation, just assumes, okay, let's just recognize Haida title to everything and focus on the real questions here. Because when you think about conceptually, what is the test for title? It's proving that when Europeans arrived, First Nations were already there and that they were on their lands. But if you ask any person, even like an elementary school student who was there when Europeans arrived, they already know that. So why as a legal system are we so fixated on this question, which is so obvious, and it's a distraction from the real question, which is, okay, let's just assume that we're both here and that we both have title, and how are we going to work together? How are we going to live together? How are we going to manage lands? How are we going to, allocate resources? How are we going to reconcile jurisdiction, assuming that both parties have sovereignty, both parties have title, both parties have laws? That's the real question, and now that's essentially the next step in this conversation. In the Rising Tide Agreement, it has recognition that not only of Haida title, but all the parties mutually recognize that each other has jurisdiction arising from their own laws, and it establishes a transition process in which they'll negotiate how to reconcile jurisdiction on particular areas, and that the conclusions of those negotiations will then be added to the main agreement as appendixes, working through how are we going to manage forests, how are we going to manage protected areas, how are we going to manage, all the different types of land holdings on Haida Gwaii. So it's a really interesting process, and we'll see how it shakes out. But what's implicit in this agreement is that it's recognition essentially by the Crown that it is possible to have a coexistence of Aboriginal title and private lands, and that that's only possible if we understand Aboriginal title as this public law interest in land. So the other case study I wanted to look at was submerged lands, meaning riverbeds, lake beds, oceans. Like, how does Aboriginal title apply to that? And reframing our understanding of Aboriginal title as a public law interest in land based on the sovereignty of Indigenous nations allows for Aboriginal title to extend to submerged lands and to marine spaces. So if we look at things like, we have international law of the sea and UNCLOS, and that deals with, the rights of different nations in relation to oceans. But First Nations aren't considered states and included within that realm of international law. We have, examples in Canadian law, like the, Andrew had referred to the Georgia Strait reference, which is a battle over, who does the province or the feds have jurisdiction over certain, submerged lands within BC. But Indigenous jurisdiction and title is totally ignored in that case and in that discussion. Similarly, for example, we have Section 8 of the Oceans Act, which says that, Canada has title to all of the territorial sea, except for those lands which are held by the province. So again, it's reinforcing this false dichotomy of, it's either provincial or it's federal, but there's no acknowledgement whatsoever of, what if it's Indigenous? To date, the courts have just, and the governments have just totally ignored this fact. And so Robert Hamilton talks about this problem and this oversight in one of his articles here. And he says, Racist legal fictions, such as the doctrine of discovery and terra nullius, extended the sovereignty of nascent nation states over vast territories populated primarily by Indigenous peoples. Territorial sovereignty being a conditioned precedent to sovereign rights in coastal areas, denying Indigenous territorial sovereignty had the effect of excising Indigenous jurisdiction from marine spaces as well. Indigenous peoples were thus deprived both of jurisdiction and property in marine areas. Discovery obviated their jurisdiction, and the European view that the sea could not be the subject of proprietary interest undermined traditional forms of Indigenous tenure. So that's an example. That's an old part of colonial thought from Europe that goes all the way back to people like, Vattel and Grotius and stuff, where they saw that the sea was a commons. It's so big and so vast and has, endless fish in it, and any person who mixes their labor and, goes and catches the fish, that's their property, and no country can claim that. Now, what we know of the world is very different, actually, and for example, a lot of fisheries in BC are in a state of decline or collapse from overfishing, and it's this idea that the sea is this endless commons is simply not tenable anymore, and also the idea that by doctrine of discovery that these lands and oceans became subject to the crown, that's also not tenable anymore either. So what does that mean for what is the nature of the Indigenous interest? And if we look at property as the analogy for Aboriginal title, then it doesn't really work, because we don't have little fee simple plots of ocean out there. That doesn't exist in Canadian law. However, Canadian law does contain recognition that there is public law jurisdiction and title to oceans. And so if we see Aboriginal title as this kind of public law interest that's more analogous to a province or to federal title, then all of a sudden it is possible that Indigenous people do and always have had title and jurisdiction over oceans and rivers and lakes and other submerged lands. So Hamilton says another quote here, which I wanted to share with you. He said, even where rights regimes are more amenable to Indigenous claims, they often fail to adequately address Indigenous concerns about the use of marine spaces and resources. This is due in large part to the fact that common law countries have tried to wedge claims for Indigenous jurisdiction into a rights paradigm. Contemporary rights regimes obscure the bodies of Indigenous and intersocietal law outlined above by framing Indigenous claims as claims to engage in discrete activities. In doing so, contested constitutional relationships are treated as discrete rights claims for a cultural minority. The question of Indigenous peoples' place in the constitutional framework is thus bypassed. So this issue has been a live issue recently in the courts. One example is the Osgoode Nation versus Canada case, as well as Thomas and Saikuz First Nation versus Rio Tinto Alcan. So the Osgoode Nation case is has two components to it. One is a treaty law case about the ownership of the Bruce Peninsula, and it also has an Aboriginal title case in which they say that the Osgoode Nation also has Aboriginal title to the lake around the Bruce Peninsula. And I was reminded during Kent McNeil's conversation where he talked about how the Crown doesn't really understand the Indigenous perspective on treaties. Like one example is, we were intervenor counsel in that Ontario Court of Appeal on the Osgoode case, and even today, Canada and the Crown is still arguing that, for example, the Treaty of Niagara is not a real treaty, and therefore Osgoode doesn't have title. Like that, even now, the Crown is still making these types of arguments. And then on the title to submerged lands issue, they had a variety of arguments. One of which is that there's an irreconcilable conflict between Aboriginal title to submerged lands and the public right of navigation, and that this common law right of navigation should oust even the possibility of having a constitutional Aboriginal right, which is the total reversal of these interests. You would think that a constitutional right would take precedent over just a regular common law right, and yet the courts have been, treating this as backwards at the behest of, Crown arguments to that effect. So in both cases, the trial judges grappled with whether Aboriginal title to submerged lands was even possible. So this is a quote from the Saikuz decision, which is about, title to a riverbed in northern BC. And the court said, even if I were to find that the plaintiffs had met the criteria considered by Justice Matheson or required by the Silcotin construct, the conflict between the exclusivity of Aboriginal title and the primacy of the public notice that word primacy, of the public right of navigation might still provide a potentially insurmountable barrier to finding Aboriginal title in this case. In fact, on the face of it, it would appear that to be the case for any Aboriginal title claim to the bed of a navigable waterway. So both cases have gone to the Court of Appeal. In Saikaz, the court side-skirted the issue. They said, oh, this is better dealt with in Ontario under Saugeen, where there's better facts. And then the Court of Appeal in Saugeen said, well, actually, there's not enough evidence of Saugeen title to the submerged lands. So, and then the court refused in Oberter to deal with this issue of whether, how Aboriginal title and can exist in submerged lands and coexist with this public right of navigation. But the Court of Appeal in Saugeen did soften their stance a bit they said, okay, we're no longer going to say it's impossible. So the court said, in some instances of Aboriginal titles to submerged lands might have practically no effect on the public right of navigation and might be entirely compatible with it. So they said, actually, we're going to take that back a bit. We're going to agree that it's possible and leave it to be decided in another case in which the First Nation has the ability to meet, the burden of proof of proving Aboriginal title. But again, that shows another problem with this whole system. Why is it that the Crown is just assumed to have full sovereignty and title, and yet the First Nation has the burden of proving it? We have these constitutional rights under Section 35, but until they're proven, they just exist in this, abstract and amorphous state with no practicable effect. And the requirements that First Nations are required to do to prove title, if you go to litigation, it's massively expensive. The evidentiary burden is huge. And in most cases, the courts still denied. They say, oh, you didn't have enough evidence of proving this obvious fact that when Europeans arrived, First Nations were already there. Like, how much proof do you need? And then if you go the negotiation route, to date, there's been a lot of problems with, this kind of take it or leave it approach that the Crown has been taking in negotiations. That's why there's just not a lot of, modern treaties in BC is because of, I'm not going to get into it now, but there's been a lot of problems with the way in which, modern treaty negotiations have been taking place. And that just leaves First Nations in a really, tough spot of, we have these constitutional rights, but in law, it's like they don't practically exist until you prove them by doing this, spending all this money and jumping through all these hoops. But what is, kind of one part of the step of change is acknowledging that Aboriginal title is this public law right, because then at least you can get the courts to agree and understand that it's possible, because they're just grappling now with, is it even possible to have title to submerged lands? And the answer is, of course it is, but we need to have this perceptual shift if we're going to get the courts to get to that point. So the last thing I'm going to talk about today is Indigenous laws and Aboriginal title, looking at, the Cree legal order and how, changing the way we understand title to this, public law framework actually aligns better with the way that First Nations understand our relationship to land. So reconceptualizing Aboriginal title as a public law relationship to land grounded in Indigenous sovereignty creates space to shift our understanding of title in a way that recognizes Indigenous laws not only as proof of title, but actually as its source and its substance. So the case law on Aboriginal title has already recognized Indigenous property laws as evidence of use and occupation. So for example, in Delgamuukw, the plaintiffs had, voluminous evidence of the Gitxsan property law system, which, Dr. Val Napoleon analyzes in her scholarship, drawing upon the record that was before the court and saying, look, Gitxsan had a vibrant and rich property law, tenure system, and that a lot of Gitxsan property law concepts are analogous to European ones. Like, in Gitxsan law, we have our own version of a life estate. We have our own, versions of easements. We have, there's a lot of ways in which our system has, really good analogies. And, counsel in that case really pushed that argument saying, see, we're legitimate because we have similarities to European laws, which you understand and recognize. So you should recognize us as well. But there's also ways in which Gitxsan law doesn't quite fit this Canadian conception of what property means as well. And I think that was why it was lost in translation. Justice McEachern just wasn't in a place of being able to really comprehend what was before him, because he had this really narrow mindset of, what does property law look like and what is, how do you prove title? But again, if we're looking at Aboriginal title as property, then, the Indigenous law, it's just a proof of these elements. If you have a trespass trespass law, well, then that's proof that, that the First Nation had exclusivity, for example. But it doesn't really see these laws for what they are, just as, proof of something else. So Fraser Harland is a scholar who critiqued the court's approach to treating evidence of Indigenous laws in Aboriginal title, particularly in the Silcoteen case. And he said, considered only as evidence, Silcoteen law was relegated to the realm of history and was accepted only for the purpose of establishing the extent of occupation and not as law by the courts. In essence, Silcoteen demonstrates that Canadian courts are only willing to engage with Indigenous laws as historical and evidentiary fact. They continue to deny its existence as a normative order in the present that could inform the legal test to determine title, the benefits that title bestows, or the law that would function in the title area. So another recent case, which I didn't include in my slides because I didn't want to get too long, but I'm just going to tell you guys about it anyway. There's a really cool case out of Quebec, R versus Montour, looking at, Mohawk right to bring tobacco across the border. And the judge in that case just went wild and said that, never mind what the Supreme Court of Canada said, never mind the Vanderpeet test. I'm just going to make my own test for Aboriginal rights. And it's going to be one in which, looking at the Indigenous law system and saying, okay, is this right protected by Indigenous law? Then the Canadian law should recognize and protect it as well because of that, historic treaty relationship with the Mohawk. And that just totally rewrites the test in which now Indigenous laws aren't just, proof of something else. They're actually the basis for the right itself. And I think this shows that that type of change in thinking is possible. So if you can do it in the context of Aboriginal rights, why can't we do it for Aboriginal title as well? Why can't we just, never mind trying to show that First Nations had property rights and just look at our own Indigenous law systems and say, okay, what do these Indigenous law systems say about Indigenous relationship to land? And thus find a way to make that fit within, to get recognition within Canadian law. So another example, before I get into the Cree laws, is that like what the court does right now with the test is that you have, all these different Indigenous legal orders. The First Nation uses them as proof of, the test for title of exclusivity or of continuity or whatever. But then the right you actually get is standardized. Like Aboriginal title looks the same anywhere in Canada. So you're taking this beautiful diversity of Indigenous law, using it as proof, and then what the court is giving back is recognition of this cookie cutter right of Aboriginal title. So in this case, these Indigenous laws are then domesticated and subsumed within this common law property framework. So we're taking Indigenous sovereignty, we're taking Indigenous legal orders, taking Indigenous relationships to land, and we're changing them and transforming them into this property law right, which makes us appear as less than we really are. It makes us appear as these, groups of landholders squatting on our own territories. And it ignores that we are nations, that we have sovereignty, we have laws, we have our own property regimes, and our own relationships to land as well. Another random picture of my family. So I'm going to look at Cree law just as an example of, what does Indigenous relationship to land look like? And this is just one example. There's lots of different legal orders, Indigenous legal orders in Canada. And I also want to acknowledge that like this, the next few slides, I sat down after dinner with my father-in-law a couple of weeks ago and we just had a chat about, okay, what does Cree law around land look like? And these next few slides are a summary of that conversation that we had. So in the Nehio or Cree legal order, if you title or relationship to lands is relational. We have this concept of wakotoin, of kinship with the land under natural law. So we must show manatsuin our respect to the land and everything under it and over it, all of Earth's creatures. We have no right to take a plant or any of Earth's creatures unless we ask permission first. Nehio people refer to the Earth as Gikawinau Aski, our Mother Earth, and she offers us many gifts to look after our whole being. Another article I wrote talked about this concept of Gitxsan, or pity and compassion in Cree law, and the idea that before the land and before the Creator that we're pitiful beings. We're dependent upon the air to sustain us, on the water, on the plants and animals, and we wouldn't survive even one day without the assistance of all of these gifts. We must always give in return and look after the land in accordance with Manitou Yesuewina, the Creator's laws, not only for today, but for all generations to come. We call this Gamakoya Gikanuyao, to look after our mother. And the elders told us, Eho chika kikawinao aski, we come from our Mother Earth. Further, they tell us, Kanaka tokia kikawino, we provide for our mother, the earth. And our relationship with the land is inaskata, which means that it extends. So thinking about it as extending over generations or over time, that relationship is ongoing. In Nehiyawiyasuewana, or Cree law, one cannot truly own land in a Western sense. This is where our Creator placed us, and we are thus the custodians of this land. So for this reason, we refer to the earth of Gitxi Amiksoin, or a sacred gift. Another way you could refer to this is Gitawi Kosoin, or a sacred loan. And so the teachings behind this is that when we're born, the Creator gives us many gifts. We're given the gift of Pimatsuin, of life. We're given the gift of Waskawiwin, of movement. We're given the gift of breath, which is Oskatamuin, Egwa Batamuin. It's two different words for breath, for the exhale and the inhale. We're given the gift of our mind, Mamtochigan, and the earth, the Aski, the water, the Nipi, fire, Iskoteo, all of these gifts which we receive. And, we don't own these. We don't own our life. We don't own the earth. These are sacred loans, and we use them for a time. And when we pass away, we return that. Our breath goes back into the air of the universe. Our body goes back into the earth. Our life, our Pimatsuin, transforms and goes into its next state of being. And so we just hold these for a time, and they're all a sacred loan from the Creator. And the land itself is part of that sacred loan. So we're not really the owners, but we do have a special relationship. We are tasked with the responsibility of being custodian with it for a while, and then we pass it on to the next generation. In Cree culture, we also win, our wealth is not personal, it's something that must be shared. So for example, if you're machi or hunting and you catch a buffalo, you have an obligation on that hunter to share that, especially with vulnerable people in the community, elders, people that can't hunt for themselves, but just more generally as well, to use that, not just for his or her personal benefit, but for the, collective benefit of all. In Nehio and other neighboring Indigenous nations, we each had our own territories, and which included boundaries or markers. So a territorial boundary in Cree law is referred to as Tipahaskan, which we could not cross into another tribe's boundary without asking permission first, and they would be allowed to repel us with force if we did that. And we have stories in our oral history of fighting to protect our lands. There's also a rule in Cree law that you must not commit violence upon travelers who are just passing through, particularly in the context that there's a lot of sacred sites spread throughout our territories, and you would have people or communities traveling as pilgrims to go visit these sacred sites to do ceremony and to pray, and so they'd be protected under Cree law. That's not a transgression to pass our boundary if you're doing it for those reasons, or if you're coming to to trade or whatever. There's ways that we had ways to resolve, disputes within Cree law. Sometimes force was used, but we also had contests which were used to settle disputes as well. So they would say, okay, let's see who is the best at archery. Horsemanship is another thing. I don't know how you call it in English, but it's like, can you sneak up on the enemy and touch them without them realizing you're there until you get there? But that's another way they have a contest is, who could touch the chief first without any of the warriors noticing. So these are horsemanship, dance, song. So the origin of powwows is that they have always been competitive, and powwow dancing was, historically a way of settling disputes in this way. See who's got the best dancers, are the best singers. Like, there's a long history behind that. More dancing. So this is these pictures come from a piece from my family dance group called Raven Mother, and it was tells the biography of my late grandmother, my Nokompan. Her name was Mushkegowuck Iskwe, or the strong woman. So it talks about her life and the role that she played in the resurgence of Indigenous dance in Canada. So that's where these images all come from. So, okay, we're almost done here. In Nehiyawiyasuewana, or Cree law, the land itself is animate. So one of the sayings in our culture is Kakio Kigwai Achakomaga, which means everything has a spirit. And An example of a transnational or international law in Cree is this idea of treaties. So one of the words in our language for treaties is tapamahtuin. And in our culture, the treaty is considered to be sacred. It's an oath before the Creator. And thus, our promises are binding under natural law. So, like, for example, when our community negotiated, like Onion Lake was involved in negotiation of Treaty 6, they had, many, many days of fasting and ceremony, and, they would have pipe ceremonies, sweat lodge ceremonies, like all these things to really seek, spiritual guidance on what should be the terms of the treaty, what should be included in there. And so in that sense, because of that, approach to it, this is not just a, positive law relationship between humans. It becomes a sacred commitment, a promise made before the Creator. And because it thus becomes absorbed into natural law. And if you break a treaty, or if you break any kind of natural law, there's consequences to that, which impacts not just the individual who did it, but also their whole community. It can bring disaster. And there's lots of stories in Cree oral history of, someone breaks natural law and then some kind of natural disaster occurs or something like that. And so we refer to these natural law consequences as pisastigan, or the Creator's whip. That's also similar to the imagery of, like in powwows, we have the whip man who is responsible for enforcing the protocols on the powwow. That comes from the same kind of imagery of this, Creator's whip. This law applies equally to both parties of the treaty, to the Nigxiowak, to the Crees, as well as to the Muniowak, or the non-settlers who were part of those treaty promises. Our ancestors prayed, fasted, they did ceremony for weeks when they negotiated the treaties. They took the time that they needed to arrive at the right promises, and we recorded each promise on kutawasik tapatimuin, which are the treaty sticks. So you think of that as like a bundle of sticks representing each of the promises in the treaty. And something my father-in-law talked about is this idea that if you look at that bundle today, there's not very many sticks left that haven't been broken by the Crown, over this history of colonization. There's a whole, long, complicated history about that right now. One of the live issues right now in Saskatchewan is negotiating settlements for cow and plow, which was one of the promises under the treaty that was never fulfilled. So where does this all leave us? I'd say in conclusion that the courts have mischaracterized Aboriginal title as a sui generis property right, when actually it's a public law interest in land that arises from Indigenous sovereignty and comes from our own Indigenous legal orders. Conceptualizing Aboriginal title in this way is necessary because without it, Aboriginal title can't coexist with fee simple. We can't have Aboriginal title to submerged lands, into ocean spaces. And so we really need to change the way in which ourselves and the courts think about Aboriginal title in order to achieve reconciliation in respect of these interests. Further, changing the way we understand Aboriginal title as coming from Indigenous law allows us to change the way in which we understand the applicability of those Indigenous laws themselves, that they're not just proof of this cookie-cutter property right that First Nations may or may not have, depending on if they can meet the burden of proof, but that those Indigenous laws are binding of their own accord, and that those Indigenous laws and relationships to land under Indigenous law is both the form and the substance of that right of Aboriginal title itself. Now, if we approach Aboriginal title from this starting point of acknowledging that Indigenous peoples were nations, that we hold title, we hold jurisdiction, and we have legal orders, we're not just collectives of landowners, then this will facilitate a relationship that's based upon respect and it's necessary prerequisite to achieving reconciliation. Yeah. Thank you all for listening.